on there. So if you have questions at any time before class, during class, after class, there's a general chat. There's just a generic ask a lawyer. So if you want to just ask random lawyer questions, we've got that. And then we've got special channels that only you guys of the summer program can see about the homework. And there's also some voice chat channels. So when you guys are practicing with your trial teams, you can get in a Discord and practice that way. Or if you want to talk to some of your fellow students about the homework, or even if you catch myself or Lexi or Felicia, unfortunately, we haven't gotten Judge Sullivan Discord yet. But if you want to talk to the rest of us, you know, if we're available, you can ping one of us and we can hop in the voice chat. So that's probably the best way to get a hold of us, because all of us are monitoring it. You guys should have our emails. If you don't, we'll get them to you. But that's probably the best way to get a hold of us right now is the Discord. And then if you have any specific questions for Judge Sullivan, you can send them directly to me and I'll make sure he gets them, because I talk to him a lot. So yeah, I just want to make sure for communication, please join the Discord. Again, the link's already in the chat for Zoom, and I'll add it again at the end in case there's any latecomers. So that's it.
All right. Again, it's all about communication. We're going to cover tonight case preparation and strategy. Again, if you got any questions, just hit it on the chat. We're also going to go over, if you got any questions, we're going to start off going over your video handout. The video you're supposed to watch, you had to fill in the blank homework assignment. If you got any specific questions you want answered on that, I can answer that for you at the beginning. But we want to start off. This is a serious task you're undertaking. You are representing someone with real cases, right? They got a real citation. It's a major responsibility when you got someone's life issue in their hands. It might sound minor, a citation. It's still a juvenile record that they could have. So it's a very serious. I'm a judge. I preside over cases of child abuse and neglect. I take it very serious. And the key is preparation. Now, you need to be prepared. Whether you are prosecuting, you are defending, you need to be prepared. If you don't, it's unethical. It's unprofessional in a sense on that. You take responsibility to your client. And there's nothing worse. I see it in my court in real adult cases where it's obvious the attorney is not prepared. They have not done their homework. They haven't had their questions prepared. They're all over the place. It's obvious to the judge, and I will mention it to him. At the end of the trial, I will call the attorney up to the bench and tell him, you come to my court, you better be prepared. If you're not, then don't even show up. So that's very important for trial by peers to be prepared. And we're going to start tonight. I keep saying tonight, we used to teach the classes at night. We'll start today by talking about case preparation. But the key is remember your 5 Ps. Prior preparation prevents poor performance. If you remember your 5 Ps, no matter anything you do, you'll be fine. Prior preparation prevents poor performance. Be prepared. And that's the one thing I want you to take from today's presentation is preparation. You need to be prepared for your case. And that means prepared with the facts of the case, what your case is about, your witnesses, all the witnesses, statements made to the police, statements made to school, any documents that they've submitted, the police reports or statements by the individuals, what the witnesses have to say. You need to review everything and be very, very prepared to your case. You need to know it inside and out. I promise you, as a judge, I will know that case inside and out. So if I'm going to know it inside and out, I expect you to know it inside and out. So you need to be prepared in your case. Preparation, and you'll be just fine. You're going to have co-counsels. That means you have another attorney working with you, another peer counselor. It's important that both of you are totally prepared. You just don't say you do half, I do half, but that's great. But you still got to be prepared for the other half. Maybe your co-counsel gets sick. Maybe your co-counsel can't make it to the trial. You have to stand up and do the whole thing by yourself. So it's important that co-counsel are both familiar with their entire case so they can step up and do the whole case if need be. Otherwise, of course, just breaking it up in between the 2 co-counsel is totally appropriate. One do opening, one do closing, one counsel question one witness, another counsel question another witness. That's fine to share the load equally, but make sure you're prepared that you can handle the case by yourself if it happens. So that means you really need to communicate with co-counsel again to be prepared. So that's kind of what we're going on that you're both responsible And please be prepared for your case. You have someone's life, you're representing them in their interest, so it's very important to be prepared. Mike, anything you want to add, Mike, on preparation or anything?
Just, I know you guys see a lot of exposure to attorneys and lawyers and court stuff, mostly through TV and things like that. And it always sounds like they got the big aha moment. As someone who does trials in real life, there are very, very, very few aha moments. If you find yourself on the end of an aha moment, it usually means you didn't prepare for something. I thought when I went into law school, especially when you're talking about like cross-examining witnesses or stuff like that, there'd be a lot of thinking on your feet. And while there is that, 95% of what you do is all done beforehand. It's all the work you put in a trial. The trial is the product of all the preparation that you do, like Judge Sullivan said. So the more boring a trial is better for you, because that means you were so prepared, you knew almost every avenue, every outcome, every possibility, because you know everything. I mean, you almost have to literally be, waking up in the middle of the night reciting your facts, and that, and I know that kind of sounds scary, but that's what happens. You get to know your case so much that you can just instantly recall anything, and that way you're not, you don't have to think on your feet as much. So that's just one perception that I had before I went through law school and became a lawyer. You just see all the flashy stuff on TV. You guys are probably too young for know what Matlock is, but it was like the Matlock moment. He's got a witness on the stand and no one knows what's going on except him, and all of a sudden it's aha, so that happened. That just doesn't happen in trial by peers. It doesn't happen in regular court, or it shouldn't. So one thing, and we'll get into that a lot later, but one thing to add on to that is that includes preparing whatever witnesses that you call. You want to make sure that your witnesses, they're going to answer things in a manner that you're prepared for. There's no worse feeling in the world than putting a witness on the stand and finding out information from their answers when they're your witness. And that's coming from someone that's had it happen to them before. And sometimes you can't prepare for that, but that's where the thinking on your feet comes from. But it's just really, this is a long-winded way of saying preparation is 95% of being an attorney.
Yeah, as Michael said, there's very few surprises at trial. We do discovery, which means you get the evidence before trial, right? You get the citation, right? The ticket, you get the statements, right? You get police reports. So you know what's happening on that. You should know basically what the witnesses are going to testify to. If it's in the documents, you're going to interview your witnesses, right? And let them know what questions you're going to ask them, so they're prepared to answer that question. So as Michael said, there's very few surprises at trial. There shouldn't be surprises. You get all the evidence. You don't find out what's going on at trial. You don't find that out when you're asking a witness. Now, you never ask a witness a question that you don't know the answer to, because you might not like the answer. So you want to be real careful on that. So you know what your witness is. You prepare them on that. There should be no surprises at trial. You get all the discovery. We don't do trial by ambush. The parties have to share their discovery unless it's privileged. So there's no trial by ambush. Everybody goes in, kind of knows the idea of what's going on in the case. And your goal is to persuade the jury and the judge as to why your case is right, why the person is guilty or why the person is not guilty, depending where you're at. That's your role on that. So there really will be no surprises on that. You should know exactly kind of what's going on from reading all the discovery, all the statements, interviewing your witnesses, re-interviewing your witnesses before trial. So there should be no surprises. Did you have any specific questions on your video handout, fill in the blank? If you had any questions on that, we can cover that before we jump into our case preparation. And we're going to break into 3 parts for you. But did you have any questions on your fill in the blank, or would you like me to go through the answers with you to see if you have any? We'll kind of sit there and see responses, see if you have. Okay, we saw a couple questions on that. Okay.
We have a question about homework that I'll let Katya answer, but looks like the first question I see here is, what are the standards of proof? Do you want to go over there, or would you like me to?
All right, Mike, that's question number 8 on your handout. It says the standard of proof of trial by peer cases is, Michael?
So the standard in trial by peers is beyond a reasonable doubt, but there's multiple standards of proof in court. There's what's called preponderance of the evidence, and preponderance of the evidence is, I'm going to explain this in percentages, and you're the judge, so maybe you can adjust my numbers, but preponderance there is like 51%. It's more likely than not that that person did it. The next step is the next level is clear and convincing evidence. And what that means is you're almost positive that person did it. It's about 90%. And then there's beyond a reasonable doubt, which I'm sure everybody here learned or knows from TV and everything. And that's pretty much a standard for a criminal case. And that's 99%. You can't have a single reasonable doubt in your mind, because if you do, then just by our laws and constitution and everything else, then it's not considered beyond a reasonable doubt. Nika, I hope I'm pronouncing your name correctly, but that is correct. The trial by peers cases are criminal cases. You're receiving citations from school police officers or regular police officers. And these kids, the subject minors, as we don't call them defendants in our program, but our subject minors, what happens is instead of going through real juvenile justice court, they come to our court program. They go through whatever court proceeding they decide to go through. If they're going to plead guilty or if they're going to go to trial, then we give them, they have their day in court, and then if they're found guilty or plead guilty, they get sentenced. And then after they complete the requirements of that sentence, then their record goes away. So it's kind of a benefit for them to go through our program. So it looked like a lot of questions on question 8. I saw that in the Discord as well. So there's multiple standards of proof. Judge Sullivan and I deal with cases that, depending on what stage of the case, it's either preponderance of the evidence or clear and convincing, but criminal cases and trial by peers are beyond a reasonable doubt.
Yeah, and again, remember what we're here for. The reason it's that highest burden of proof on the criminal standard is because our youth are what we call delinquent. We don't call them criminals because they're minors, right? So we don't want to treat them as criminals. We call them delinquent, which means they did an offense that if they were adults would be a criminal, but we call it delinquent just to show that it's a minor on that. That's why we use that highest burden of proof. These kids in real life in juvenile court could be locked up, could be detained. That goes to the highest burden of proof because these people could be found not in our program, but in juvenile court, they could end up being locked up. So that's why we use the highest burden of proof beyond a reasonable doubt. So that's what the state has to prove. Prosecutors, you must prove your case beyond a reasonable doubt to the jury. Defense, your role is to raise a reasonable doubt. You don't have any. Defense does not have to prove nothing. And many times all defense works on is raising doubt. If you raise reasonable doubt, then the jury must find them not guilty and release them on that. So that's the highest burden of proof, and that's why we use the criminal standard in our delinquent cases. Any other questions on that handout? Before we go on, that was question 14. Okay, let me see. I saw something on question 14 was each element of your sentence requires. What happens? Your sentencing. We're going to cover this a little bit today, and we'll do it right now. If they are found guilty or they plead guilty, there is a sentence. The sentence has to be community service, 8 hours to 40 hours for each offense. Because they're charged with 2 different crimes. They have to do 8 to 40 hours on each, depending on what the jury decides. They have to do jury duties on each, 1 to 3, depending on the severity and what the jury thinks. They have to do at least 1 workshop on each, and they have to do a letter of apology. So question 14 is telling you, if you are the state and you're arguing that this person should have 3 jury duties, you need to argue and tell the jury why they should do 3. Why not 1? If you're arguing they should do 32 hours of community service, why? Justify that. So you must justify what sentence you're asking for each element. Why? The severity of the offense, the harm they've done, things like that. So that's what question 14 is. You must, to the jury or to the judge, you must justify or argue each element, why the community service, why you're asking for that amount of hours, and why it's fair and just. Because remember, the goal of trial by peers is not to find people guilty, it's justice. So you need to explain why your sentence is just and fair. Why is the community service right? Why is it trial by jury duties fair and just, that you're asking for? Why is the workshop appropriate? Why is a letter of apology? And again, a letter of apology can be, longer, shorter, depending on what you think. Defense, same thing for defense. You want to argue, right? if your client is pleading guilty or found guilty, you may want to argue for a lesser sentence than the state. So you want to argue why it should only be 8 hours. States arguing, maybe the state's arguing 32 hours. You want to argue why it should only be 8 hours or 16 hours. State saying it should be 3 jury duties. You want to argue it should be 1 jury duty. Why? You have to justify that or argue that to the court. So the judge or the jury, again, remember, your goal is to persuade. To persuade. It's what attorneys do. They try to persuade the court. They try to persuade the jury to their side on behalf of their client. So that's what question 14 is asking. You must justify each sentence requirement that you're asking. Why you're asking that many hours for community service, why you're asking that many jury duties, why you're asking for that particular workshop, and why the letter of apology is appropriate and how long that should be. This is Mike. Anything you want to add, Mike, as to question 14?
I think you answered question 14 well. The actual answer we were looking for is argument or justification. I think in the video we use the word argument, but it's the same concept. And we're going to get into that later and teach you guys how to do that. But essentially, as we've had in the past, where people say, well, we think it should be 8 hours of community service because it's fair. Tell me why it's fair. Tell me why 14 hours of community service is better than 10. You have to explain yourself. And that's why the closing arguments that we ask for, right at 5 or 10 minutes, because you don't always go, we want 14 hours of community service, 2 jury duties and 1 class. Thank you. That doesn't give me the jury any explanations to why you're justifying it. So I do see one more question. We will get into the restorative justice, the encounter concept. Essentially what that is the whole point of restorative justice, and we'll get into it later, but I'll go really briefly. Is this, you got 2 kids who got into a fight. And you know what, actually, I take that back. We're going to circle around to that answer later. Don't let me forget to go over the encounter portion, because when we talk about restorative justice, we'll go over that in a little bit more detail, because it's part of the whole overall overarching theme of trial by peers.
Yeah, and again, as Mike said, we'll go into more detail, but basically the bottom line is just to rehabilitate, not punitive. And that's kind of what the whole juvenile system's all about. We're not here to punish the youth. Even in the real juvenile court, we're not there to punish the youth. We're there to rehabilitate the youth. What can we do to change that youth's behavior so they stop doing that, so they don't end up continue doing that and back in trouble? So that's kind of the bottom line for restorative justice, based on rehabilitation, not on punishment. And Mr. Sullivan will get into that later in a little bit more detail. But that's the bottom line. We want to rehabilitate, change your behavior so they don't keep doing the same wrong conduct that gets them in trouble.
All right. I think what we'll do is, so we don't need too much time, but if you guys got other specific questions about the handout or the homework, either ask them in Discord or you can ask me in the chat. I'll definitely answer them. But we got a lot of material we want to cover, and some of the questions you guys are asking are going to get covered in the material today. So we can start going over those. But if you have specific questions about the homework, just hit me up in chat and I'll respond to it or tell you we're going to be covering it. So.
All right. And again, at the end, we'll leave it open for questions as well. So if there's any questions that come up to you, just let us know on that, or at the end. Before we conclude, we'll ask if there's any outstanding questions, so we'll give you another shot at anything that you want to answer or any questions you have. Again, this is your first session on case preparation and strategy, and we're just going to keep building. We're going to take your case, and we'll keep building on it on each session you have. So don't panic as we get there, and then by the end, you'll be doing your own trial on that mock trial. You take everything we've been working on throughout and be prepared to go to trial. And that's what it's all about, is preparing you to go to trial in this case. So we're going to start off with case preparation and strategy. What do you do? When do you start getting ready for your case? All right, and that's what we're going to talk about. When do you start? Well, you should start at least 3 weeks in advance. You hear that? 3 weeks in advance, not the night before, right? Thank you. We got some good answers there. Feel free if you want to answer the questions on the chat. Absolutely. We want to make this interactive. So absolutely 3 weeks in advance. Don't wait till the night before, right? Because you can't do it, number one, because you got to meet witnesses and things like that. But you need to get your case 3 weeks before your trial date. You need to, number one, what are you going to do when you get your case? What's the first thing you're going to do when you get your case? And we're 3 weeks before. What are you going to do?
Somebody can maybe want to unmute their mic and tell
Yeah,
us.
tell us. Yeah, jump right in if you want to. What are you going to do when you
Read
get
all
your
of our
case?
materials and get familiar with the case.
Can you introduce yourself? Who is that?
Naika Belizaire.
Okay. Nika, and what do? You're going to read your case? Would you say repeat it for everybody? Okay, Nika?
Read the case and become familiar with all the facts and all the witnesses that are involved in it.
Absolutely. Nice job on that. We got an attorney there already. Read the case from beginning to end. You get your file, right? Read the facts. Maybe make an outline. I like to, in my cases, I like to write the facts are the key facts that I want to remember. And then I put down the witnesses. And I put the witness that, and I put down underneath that witness what facts I want that witness to prove for me during trial. So I get started by saying, what's this case about? And who are the people involved in that case? So you want to review that, read the case, familiarize with the facts and all the people involved, the school police, school personnel, any other people, the victim, any other people that's involved with that to get an idea of what your case is all about. So good job on that. Read your case, everything in your file, familiarize yourself with exactly what's going on in the case and who are the key people that's going to be witnesses in that case. Nice job on that. All right, so you read everything, you read the case, you know your witnesses. What are you going to do next? Speak up, someone jump in there. What do you do next?
You're gonna want to contact your co-counsel.
Okay, you do your co-counsel on that if you both get that. Now that'd be good to introduce yourself to co-counsel, to make sure the co-counsel has read the case materials and all those elements on that. But you also, when you get that case, you want to look up the law, right? You got the facts, you've got the witnesses. Now what's the law? Because before you interview your witnesses, you got to know what you got to prove, or in defense, what reasonable efforts that you are, reasonable doubt you want to raise to show the state can't prove their case. So always look up the law or the statutes. What is my client charged with, or what am I prosecuting? And what do they have to prove? What does that crime involve? So I know exactly what I have to do that. Contacting co-counsel right away is a good idea. Introduce yourself. We're working together. Talk about the facts and the witnesses at the beginning. That's great. But make sure you research the law so you know exactly what the facts are, who the witnesses are, and what has to be proven by the state to sustain the charge. Mike, anything you want to add on that, Mike?
What else? So as you guys know, because our program is a little bit more, it's more about restorative justice and helping the kids. What's another thing that you guys that may be important to do in that first week you look at the case? Anyone just?
Can I answer?
So yeah, go ahead, Gabrielle.
Okay, yeah, my name is Gabrielle Conrad, and you would want to figure out what would be most beneficial to the, like what results would help them to like get better and not come
Why
back.
is that important?
Well, because we're focusing on restorative justice. So if there's no consequences for anyone's actions, then there won't be any change.
That's correct. So now I'm going to throw something at you that's not on the outline. But that's the correct. It is the correct answer. So what if you're a defendant? What if you're a defense counsel, and you have a case, and you know you probably can legally win for your client, but you know it's not going to do your client any benefit? What do you do?
Well, because of where the focus is trying to, like if we know that they're guilty, then the goal is to get them community service and run them through programs that will help them not to commit the same offenses and not to fall back into the same cycle again. That's
100% correct. And that's something I call, you want to take your lawyer hat off and put your counselor hat on. We're actually, so when you're an attorney, you know, your title, if you will, is you're a counselor. And sometimes that means counseling your client. Now, in the real world, it's a little different, but in our trial by peers program, you need to find, and this may be the hardest thing you do in the trial by peers, is persuading your client to maybe take that guilty plea, because, and we'll teach you some tactics how to do that later in the course, but you know, that it's better for them in the long run to go through this as opposed to getting out through a legal loophole. And that was one of the things we discussed in the video is, you know, you can get them off by the law, but if this is something that'll benefit your client long-term, your job is to benefit your clients. And it might not just be just getting out of the case. So that's a very good answer.
Excuse me. I would like to add on to her comment.
Sure,
I would say
Isaiah?
that, yeah, I would definitely after doing like the next step, I definitely want to ask lots of questions just to all the parties of the case, witnesses, people involved. And then I feel like after getting to know my who I'm representing better and the opposing counsel, that I would, see what's best, what decision is best, maybe for rehabilitation or to try to get this off of the record, and maybe see what results I would explore after that.
Absolutely, Isaiah. That's a good thing on that, because many times you can't know what benefits your client until you really review everything on that. So that's a good point, Isaiah. And remember, we're all about rehabilitation. And as Michael said, Mr. Saloom, attorneys and counselors at law, and sometimes the adult attorneys in my courtroom forget that they're counselors at law, that they're to counsel their client too, and to talk about that and what's fair and what's best to help them. Again, the bottom line is we don't want them to continue that behavior. We don't want them back in the system. Someone asked a question, what is a statute or an ordinance? A statute is the written law. Statutes, state statutes, for example, for, battery, there's a definition of what a battery is. There's written law that says a battery, a harmful or offensive contact, unjustified. Those are written laws made by the legislature. And ordinance, we have the county rights ordinances. Those are their rules of conduct on that. State is the state statutes, but the city and the county many times have ordinances like curfew, an ordinance that you can't stay out after certain hours. So those are kind of the written laws made up either by the state or the county or the city. But those are written laws. So when you look up the law, you need to see exactly what is the offense, how it's defined, what you have to prove as a state if you go to trial, defense, what the state has to prove, because it's the burdens on the state to prove it beyond a reasonable doubt. So good job on that. So you got your case, you've read all the facts, you have familiarized yourself with the witnesses, you are familiar with what the charge is, what the case needs to do on that, contacted your co-counsel, like you said, to talk about that. What do you do next, Tom? What are you gonna do next? We've got all that. We've gone through the file on that. We realized what the charge is. We've talked to co-counsel, how we can handle this case. What's your next step? What are we gonna do?
Start interviewing the witnesses.
There you go. Good job. And who is that? Who's that?
Mia.
Mia.
Renia.
There you go. Absolutely, Mia. You start interviewing your witnesses, right? And that's why you got to read everything in great detail before, because you don't know what to ask your witness if you haven't read everything. And if you don't know what the statute is, you won't know the right questions to ask the witness. For example, it was willing participation in a fight. Well, was it willing? Right? Did they get jumped on? Did someone just jump them? Was it a willing participation? That's what an affray is. That they willingly participated in a fight? Well, the key thing is now you know what questions to ask. How did it happen? What started it? Who started it? Things like that. So you really won't know what to ask the witnesses till you read the file, know the statutes or the ordinance, what you do, and now you know how to interview each witness to start figuring what questions you want to ask each witness on that. And again, identify your witnesses and then what you want to get out of that witness, right? What is that witness going to testify that's relevant to the case that you are involved in? Mike, anything on that?
Just one quick thing. The Judge Sullivan just uses the law and the legal term affray, and that's what's in your case files. And we're getting done with the week 1 section, so we're going to start applying some of the week 1 stuff to the State versus Ronald Smalls here. But you're not, once you get out of the program, you're not going to see affray anymore. Then it's now a disturbance of the peace charge, which it's similar, but it's a little bit different. You'll see. We should have those statutes in there so you can see what the differences are and how you analyze those separately. Hannah, this is being recorded. Katya and or Patrick can probably let you know how to access the recording. So that's all. I think some people already have the answer for the next one, Judge Sullivan.
All right, well, good. So you got that. You interview all your witnesses, right? You've read your file. You're familiar with the facts, witnesses, the law. We will help you. Someone asked about where do you find the statutes and law. Our statutes are found in the Nevada Revised Statutes. We can show you how to do that when you get there, but we normally provide it for you so you know where that ordinances you can find in the county code and stuff, but we'll show you how to get those on that and exactly what it says. So you've read all that. You've interviewed your witnesses. What are you doing next?
I think Tilly answered that.
Tilly?
Tilly, do you want to unmute your mic and tell us what your next step is?
You probably want to reach out to your senior attorney.
There you go.
Nice job, Tilly. Yeah, you want to reach out to your senior attorney. Why? You want to brainstorm. Said, here's I read the case. Here's what I think it's about. Here's the witnesses. I interviewed the witness. Here's what to say. What do you think? So then you start brainstorming on that with that senior attorney. They can give you guidance. Say, okay, maybe you want to follow up on this, or maybe you want to look at that. So it's very important. When you get all the witnesses interviewed, is to contact your senior attorney. Don't wait till 2 days before the trial, right? Because now you may have to go back and re-interview witnesses, but meet with your senior attorney. Tell them your theory, what's going on, where you're at, and they will direct you as to what they think your next step is, or some of the problems you may have legally, or how they can help you. If you're having trouble with the law, they can help direct you on that, and they will consult with you. So it's very important to reach out to your senior attorney as soon as you're ready to go. After interviewing your witnesses, you've read everything. Now it's to meet your senior attorney, and they will direct you and talk about and work out your strategy and answer any questions you may have with that senior attorney. We have senior attorneys for all those cases there. If you're having trouble reaching your senior attorney, like sometimes people get busy and they don't return your call, just let Katya know or let one of us know, and we'll make sure that we get that contact for you, because sometimes our volunteer senior attorneys can get busy or something happens. So reach out to that senior attorney as soon as you've done your week 3 preparation. And if you're having trouble, let us know, because again, communicate. We don't know what's going on if you don't tell us. If you're having trouble, let Katya know, and we'll follow up on that to make sure you can meet with your senior attorney. And so we can do our next week of preparation. Mike, anything you want to add about senior attorneys or anything?
Who's your favorite senior attorney?
You want to ask who the best looking is, because that would be a no-brainer on that. So we'll have to say, I'm sure your best senior attorney is probably Felicia Quinlan or Lexi. Yeah, that's what we got. We got,
Thanks.
yeah, we got Felicia and Lexi tied for one and Mike's number 4.
That's, well, thanks.
I have a question.
Yes, who's that? Marie?
Yes, it's Marie Watson. So you said that before we meet our senior attorney, we interview the witnesses and everything. But if we come up with, if we are with our senior attorney and then we come up with like a strategy that we need more information on, can we go back and talk to the witnesses after that?
Absolutely, yeah. We're gonna talk about that in your fire in the next second. Exactly. Once you met that, the more questions, you say, okay, I didn't think about this, or follow up on that, then we want you to re-interview your witnesses on that need to make sure you answer all that. So good question, Marie. Absolutely. Once you meet on that, you get all up that. We want you to do that prep first before you meet with your senior attorney, because we want you guys to do the work. We don't want the senior attorney, right, to set your case out. We want you to do that prep work for week 3, then meet with your senior attorney, and then a senior attorney, Marie, can say, okay, here's some other questions I think you may want to go back and talk to this witness and ask these kind of questions or clear it up. So absolutely. And again, your senior attorney should be there for you to answer any questions you have. They normally provide you their email address, so as questions come up, you can communicate them throughout the preparation period right up to trial. And of course, during trial, if we do it live, we have the senior attorneys in the courtroom. We don't know if we do them live or not. Someone asked a question, will the trials be virtual or not? Our summer program is probably going to be all virtual because we still haven't opened up the courts. But when school starts up in August and we get our referrals, hopefully through the Harbor program, then we'll see if we're able to do in-person trials. If they're in person, your senior attorneys will be there on the night of trial, so you can consult with them during trial as questions come up. If not, if it's virtual, we can do breakout sessions so you can talk privately to your senior attorney even at the day of trial. So good question, Marie.
I just have a couple of things to add real quick while I'm answering another question. I know Tiani has something to add. I just got one comment I'll make, and then you can unmute your mic and ask your point. But you don't necessarily need to do that in order with the senior attorney. If you review your case and you have some questions on who you'd want to talk to or what you want to ask beforehand, contact your senior attorney first. The only thing that we ask is you go through your case first, so you know what you're asking, you know what you're talking to, you kind of come up with a general case strategy and plan. That way you can contact the senior attorney and get as much information as possible before you keep working. Because what you don't want to do is kind of be working on one track, not 100% sure of what you're doing, what you want to do, and then you have to, basically hit the brakes and start over. So if you're looking at a case, you're like, gee, I don't really know if I want to talk to these people, or maybe you have an available witness, but you don't think they add anything to your case, you want to talk to your senior attorney. So you can contact your senior attorney right away. In fact, that's what we really encourage you to do. But the best thing to do would be at least read over your case before you reach out. And a lot of the time, the senior attorney is going to reach out to you first. I know when I get a case, as soon as I get a case assigned to me as a senior attorney, I reach out to both of the attorneys I'm working with, say, hey, here's how to get a hold of me. Here's when I'm available. You can contact me by phone. So it depends on your senior attorney too, but it definitely helps to talk to them sooner in the process rather than later. And now that I've said that, I know Tiana, you had something you wanted to add. Go ahead and unmute your mic and go ahead and add that.
I just wanted to say that when you contact your witnesses, you also want to find out whether they're able to testify at trial.
So what said that when you contact your witness, you want to make sure they're able to testify at trial if necessary.
Yeah, absolutely. Make sure their availability. If they're going to be there, they might be going on vacation, and you need to do that soon because you don't want to wait till they show up the day of trial and say, I'm sorry, Judge, my witness is not available. And then the judge may throw your case out. So, well, it's too late now. We get everybody here. We're all ready to go. And now you tell me, unless it's a last minute emergency. So, yeah, absolutely. Good question, Diana. A good comment. Definitely. When you interview your witness, make sure their availability on that trial date, because otherwise we're going to have some issues. And again, your senior attorneys are there to help you out. So again, as Ms. Loom said, at least read your case first before you talk to senior attorney and your witnesses, so you know what's going on. And you can always interview your witnesses after talking to your senior attorney. You can interview witnesses and then follow up with your senior attorney, whatever you're comfortable doing. Again, we just want to make sure that you prep your case and don't rely on that senior attorney to do the case for you. But these are not, as Michael said, you don't have to do these in a certain order. It's just to make sure, again, preparation, whatever you're comfortable, reach out to that senior attorney, say, hey, I'm going to go ask some questions of this person. What do you think? Is this okay before I go to you? Think this is the right thing? Something else I need? And they can help you right there from day one, as we want you to make sure you feel real comfortable on that. And the more you do cases, the more you get comfortable. You decide your strategy, your style. Every attorney has a different style, so you figure out what works best for you. Good comments on that.
Judge Sullivan, should we apply to kind of the week one stuff to the mock trial problem, or do you want to wait till you get to the end and then do it?
No, let's do it right now.
You're in charge.
Yeah, let's do it right now. You got your sample case of the state of Nevada versus Ronald Smalls. So let's why don't you tell me, this is week 3, right? You have read the case materials, become familiar with the facts of what's going on. You want to tell me what's going on with Ronald Smalls, and then we'll ask someone to tell me what witnesses they would be on that. That would tie right into this week 3, right? The initial one of reading your case, becoming familiar with your facts, figuring out your witnesses. So you've already done that. So why don't you tell me?
Week 1, but you're 3 weeks out from trial.
It's week 1 of preparation, I guess I should say. 3 weeks before trial.
So basically what we just went over.
So Ronald Smalls and Michael McKinley had been getting into fights and altercations for about a week. And it all started when Ronald Smalls was playing ref in PE. And then later that day, they got into an altercation at the bus lane where McKinney said Michael Smalls snuck up from behind him. And then Ronald Smalls states that he told him he didn't want to fight, but he struck him. And then they both got a warning for that. And then on 5 days after that, they both got into a fight with Michael McKinley stating that Ronald Smalls threw the first punch and pushed him.
Good job on that, Kate. Robert, nice job on that. There was a good thing of the facts on that. It's important that you note, right, there's a prior history. That did not happen on that February 5th date, right? The fight, there was something that precipitated that with the flag football, getting rough in PE, altercation at the bus where there was a warning issued on that. So good fact on it. Just wasn't isolated that they just got into a fight over something that moment. There's something that had been brewing on, it looks like, for maybe up to 4 or 5 days. A good job on that with the facts on that. Anyone else? What kind of witnesses? Who would be the key witnesses you think in this case?
Well, I would think the teacher that.
Who's that? This is Marie?
Yes, this is Marie.
Okay, Marie. So who would be?
The teacher that caught them fighting, as well as the police officer that caught them another time, and also the nurse who saw their injuries.
Okay. You got the officers. I think there's a couple officers, Lafredo, and I think Carapucci, I think, was, when we looked at the police report, looked like they got involved. You've got the school nurse. Anybody else?
Perry and Kinney.
Who's that?
This is Stella Finnegan.
Okay.
Perry and Kinney were said to have seen the fight according to McKinney, so that they would be key witnesses.
Okay. All right. Anyone else you think?
I would look into see if any of the members of the.
What's that, Gabrielle? Is that
Oh,
Gabrielle?
I was saying that I would see if any of the kids who were playing flag football saw the first altercation, and because there were two very different accounts of what had happened on that day and very different accounts of what had happened at the bus stop. So any witnesses, like more witnesses that would have seen what would have happened could help.
Absolutely. You got the police report, with names, with the assistant principal, I think, Tiffany Sable. I don't know what she knows or doesn't know, just that she's the one that contacted the school police. You got a couple police officers, I think Lafredo and Carapucci, I think, was the one. I think it was Lafredo was the major one. You've got a campus security. I don't know if they saw anything on that. So you got all those, but good question on that. As you start interviewing these witnesses, they may give you names. You talk to your client will say, so-and-so was there. He's seen what happened. So those what happens, you might get other witnesses come up as you start questioning people to see what's going on that. So again, you're developing your case. You've read all your facts. What's the charge? What are they charged with? What's the charge that you're going to have to prove if you're the state? What's his charge?
Disturbance of school property.
There you go. Disturbance, exactly. We changed those from a fray because a fray was a real issue we had in these cases on that. So we changed it to a disturbance. Is that Samuel? Is that Samuel said that, disturbance?
Yes, it was me.
Okay. So that's your charge, disturbance. What do you have to prove for the disturbance? What's the elements of disturbance, Samuel? Or anyone else that wants to jump in? What do you got to prove in the disturbance? Is that Brianna? If you're trying to talk, we saw Brianna come up. We can't hear you.
Judge Sullivan, I'm not sure we put the actual, I don't see the law in there, but did anyone actually look up the elements of a fray?
Would you have, for disturbance, wouldn't you have to prove that something was like not a peaceful condition?
There you go. Yeah, I think if you read the citation, maybe I read more into it. I think citation indicator kind of gave it there that they created a disturbance and annoyed persons in the immediate area. So I think they kind of put the key there for you, but I'm not sure because I couldn't read it. But
yeah, the way
but that's essentially, as you indicated, that there was a disturbance and that it annoyed other people in the immediate area, right? That there's people that basically you disrupted the school at that time, or you disrupted, caused a disturbance there at Monaco High School. And basically there's other people that are annoyed by it. Just wasn't those two. They caused a disturbance that involved annoying other people or disrupting the school environment, depending exactly what happened on that. Other students that were there. Mike, anything with that? So kind of gave you the elements there without the statute being there. But
you guys will become intimately familiar with the statute starting next week in our criminal law and criminal procedure case. So we'll teach you how to look at the difference in elements and factors of a statute. So it's basically an and or an or. An and statute it's kind of like a cake. You either have all the elements or you don't. An or means you only need one of those factors. So next week or starting Monday, you'll start actually analyzing statutes and disturbance of the peace, of fray, those things, they will be in there.
And the citation will give you the law as far as, if you notice, if you read that citation, that was the ticket that was attached to your package on that. It shows the ticket. It'll show you what the offense was. And this one, it shows NRS 203.050. So it was cited many times, the statute, right, the written law that they said that they violated. But we'll show you how to do that, and that will be provided to you on the case on that. But good job. This was amended from an affray to a disturbance. So good job on it. So you got your charge we have the general facts of the case, and we have our kind of witnesses. So nice job on that. Week one of preparation. we got a good handle on what we need to go to. We go to week 2 of preparation. So nice job. Mike, anything else you want to add on?
No, I think you guys all did a good job identifying the key things. So that's great. So, and remember, this is your mock trial. So everything you do on this is going to benefit you in 4 or 5 weeks when we do the mock trials. So it's a good job you guys are looking through that now and starting to get an idea of what your problem is.
Good job. Nice job, everybody. We really appreciate your involvement. What you want to do then, now this is week 2 of preparation, 2 weeks before trial. Remember, you start 3 weeks before preparing. Now we're at week 2, 2 weeks before trial on that. You've met with your senior attorney. All right, you've talked about your case on that, and you've developing a strategy. What are you gonna do next now? You met with your senior attorney, you talked with senior attorney. What do you want to do now? What do you think? What's your next step?
Start building your case strategy.
There you go. And who's that speaking?
Catherine?
Catherine?
Brian?
Okay, I want to get to know everybody. And there you go. Okay, I see it in the bottom. That I'm old, so I couldn't see it. It was little. So we want to get to know everybody. So nice to see you, Catherine, on that. So I want to get to know you by name. You start doing your strategy, right? What is your strategy? What's your theory of the case? You always want to develop your theory of the case. What you think happened, what you're going to have to prove, or defense on that, what reasonable doubt you want to raise. So what is your theory of your case on it? If you're the prosecution, what's your theory of the case here? Your prosecution, you are prosecuting Mr. Smalls. What's your theory of the case, you think, at this point? I know we're going to kind of help you more. It's kind of tough to figure out your theory of the case at this time because it's kind of early in our training. But your key is, what is your theory of the case that you're going to, how you're going to prove the case? Basically, your strategy of how you're going to prove what you think happened at trial, or defense, how you're going to raise reasonable doubt that it did not happen the way the state says. So what is your theory in this case, you think, as to prosecuting Mr. Smalls, or prosecutors? What do you think?
My theory was that Mr. Smalls was intimidated and kind of forced into the fight.
Okay. Yeah, that's Kaylee?
Yes.
Yeah, okay, now that's your theory. That'd be the defense theory, right? That would be a defense theory. If the state thinks that happened, then the state would have an obligation to say, well, maybe we shouldn't prosecute this case. If we think that he was just self-defense, right, was forced into it, then he really hasn't done anything because you have a right to defend yourself. So, Kaylee, if that was your theory of the case on that, and then you were the prosecutor, then you'd have to do in good conscience, talk to your senior attorney and says, I don't know if we really should prosecute this youth for that because he really was forced into it, was just defending himself. But definitely that would be your theory if you're in defense, right? He was forced into this. He did not cause that disturbance. If the disturbance was caused, it wasn't caused by him. He was just defending himself. The disturbance was caused by Mr. McKinney. Good job on that, Kaylee. Anyone else have a theory of the case?
Yes.
Who's that, Caden?
Yeah, as the prosecution, I'd say that Mr. Smalls, who McKinney is about 2/3 Mr. Smalls' weight, about 4 inches shorter, and about 2 years younger. And Mr. Smalls intimidated him and harassed him on multiple different occasions. And this isn't just one isolated incident. So Mr. Smalls is in the wrong.
There you go. Absolutely. He was kind of bullying on that. He's bigger. It's been ongoing. It wasn't an isolated incident. So he's the one that caused that disturbance. He was looking for trouble. It's been going on for a while. And he's the one that caused that disturbance at the school or where it happened on that. And other people got involved. Good job on that, Caden. Someone else has kind of jumped into Caden and thought I heard a young lady's voice. Anyone else want to add on that? I heard someone's voice from Caden joining. I wasn't sure who that was.
It was me.
Sarah?
So when I read through Mr. Small's statement, he never said when discussing the actual fight, the last fight that is the reason they received the citation. He just said, and then we fought, versus Mr. McKinney, who said that he was hit first. So I would try to be proving that Mr. Smalls attacked Mr. McKinney physically, and that would be a big crux of the argument, would be to prove that he physically attacked him on multiple occasions. And then also because the inciting officer did say that he was playing rough on the first occasion during the flag football game. So it'd be proving that there's documented history of violent behavior.
Okay, good job, Sarah. And if you read the statement, as you indicated on that, of Mr. Smalls on that was attached, it's a statement report from the Clark County School Police by Officer Karaguchi on that. Always want to read their statement. That's very important. What do they say? Because their story may change when you interview them. If you're interviewing or you're talking to your client, the story may change on that. Of course, the youth, the subject matter does not have to testify at trial, of course, that cannot make them testify against themselves. They don't have to testify on that. But if you're representing Mr. Smalls, you definitely want to see what his statement is when you're interviewing him to see what's just and fair on that, to see how it jives with that. Of course, the state cannot interview Mr. Smalls because the prosecutor does not get to talk to the subject minor. An offense on that, only their counsel can talk to them on that. But you definitely want, I think Sarah brought a good point. You want to read those witness statements because you're going to use that on examination or cross-examination if a witness is testifying. Mike, anything you want to add on that?
Just, I'm reading the chat. You guys are both, everyone's making very, very good arguments for both sides about the prosecution and the defense. These are all things that are things you would want to argue in court. You could bring up some of these witnesses and have them testify to it. So I just want to comment that the discussion you guys are having are good things that you know, it's a good thought process on the case. So as you, and we'll teach you this more as we go, but as you come up with these theories, as you come up with these ideas, you want to see how you can get those into evidence, see how you can bring witnesses in, because remember, you can't just argue anything under the sun. You have to have witnesses to prove it. So if you have these ideas and theories that may help your case or hurt the other side's case, that's something that you want to try and find. Okay, now that I got that theory, I need to find out if that's true and how to get it into court. So I just want to let everyone know I'm reading everyone's comments. You guys are having great discussion with each other. That's exactly what you need to be doing, thinking outside the box for the case.
Yeah, absolutely. We got good comments. We got good chat, as Mr. Swim indicated. And also, if you read the statement of Mr. McKinney, if you notice on that, he says, I tried to call my best, this is a statement from Michael McKinney. So Thursday, I tried to call my best friend and her mom answered and said she died. And so I was already mad playing flag football. She got some things on that, wait a minute, as indicated on that, looks like Michael was already mad anyway. So maybe he initiated the contact at the flag football, then maybe he carried it on because he was still mad or not. I don't know. That's something you'd want to explore. He did indicate that he did not, that it was Smalls who pushed him first and hit him in the face. So you want to see if there are any witnesses as far as that were there that seen who started it and how it really happened. That'd be the key questions you want to ask. Who was there? What did they see? When did they see it? How did they see it? Were they across the street, right? Or were they standing right next to him? Because a lot of it goes with witnesses of what they were able to see. What time did it happen? If it happened at night, was there lights on there? Of course, those are the kind of things you want to see what they could see. So remember who, what, when, where, why, how. Those are the type of questions you'd want to start asking to try to figure out what happens on that. And also, I saw Felipe and Mr. Smalls also admitted to hitting in the head on that. So you got those things on that. Read your witness statements on that so that that will help you with the witness and interview what questions you want to ask and anyone else that might have been there. Anything else you want to add, Mike?
One thing that's very key, and it takes a lot of people some time to figure out how to do this, but you don't want to just think about your side. You want to think about, you want to put yourself in the side of the defense if you're the prosecution and vice versa if you're the defense. What theories do they have? What theories are going to help their case? Because what you want to do is find ways to argue against it. So let's just say you're on the defense and you come up with a theory that would be really good for the prosecution. Now you have to think of, okay, how do I defeat that argument in case the prosecution brings that up? So it's very important to approach the side or approach a case from both sides because you want to be prepared for any potential argument that the other side will bring.
Yeah, I think as Mr. Shalom said on that, you always want to think of what the other side's theory of the case is going to be because you want to be ready for it, right? The defense going to put their witnesses on. State, you're going to want to cross-examine their witness, right? To undermine their theory of the case on that. So you have to anticipate where they're going from, what the defense is going to say. So you're ready to counter that if you're the prosecution. Same thing for the defense. You want to know what the theory is, where the state's going to come from, so you'll be ready because that's how you do your cross-examination. Right? You know what the state theory is, or you suspect where the state's going by their opening statement. Then you get ready to try to raise reasonable doubt. State, you hear defense opening statement, you kind of get an idea where they're going, and it prepares yourself for the type of questions you want when you examine the other side's witnesses or your own witnesses that you want to get. So good job. Remember your theory of the case. Remember defense. You don't have to prove anything, defense, right? The state's got to prove it, and they got to prove it beyond a reasonable doubt, right? They have to prove it by a reasonable doubt. And defense, all you want to do if you're in that case is to raise reasonable doubt. Then by law, that person must be acquitted. If there's reasonable doubt that the jury finds, then they must acquit.
I have a question for you, Judge Sullivan.
Okay.
Why is as a judge who's evaluating the attorneys and the evidence, how does a case strategy from the attorneys help you decide a case?
I think with the case strategy, it helps put together with the case strategy on where they're going, how they got there. So it helps to lay out to me, say, okay, this is their theory of the case. Does it make sense? Number one, does it make sense? Or they pulled it out of the sky, right? They got nothing there. I've had attorneys, I'm sure Mike's had it too, when you go in there, they got nothing on their case in our family court, right? They just throw something out there. So let the judge know that they got no support for their theory when they come in there. So what it does, I look at what their theory is, and then I'm analyzing that as we're going through trial. Are they fulfilling their theory of the case? Are they bringing me evidence, or is this speculation? Is it what the attorneys tell me what happened in their theory, or is it really what happened on that based on the evidence that you're giving me? So I look at that theory, see where they're going, then I see have they taken me there, right? And make sure they get me there on that. If their theory is just out of the blue, and I know they're just pulling something out of their butt, which tells me their case is weak because they have nothing on this. When you do that theory, you want to make sure you can present evidence that supports your theory from the prosecution and the defense, because then I'm going to weigh that based on, okay, here's their theory. Did the state prove it beyond reasonable doubt? Here's the defense theory. Did they raise reasonable doubt on that charge? And I'm the judge on that. So I'll use that theory as my guidepost. Then I'll see, have you given me evidence to support your theory? Number two, and number three, have you persuaded me that your theory of the case is really what happened in that? So that's kind of how I use it as an overview of where the case is going. Tell me where you're going. Take me there.
No,
Yeah.
not really. I don't know.
I
think we got Nicholas. Did you mean to unmute? Might have been an accident.
Okay.
I think I like to avoid what I like to call a spaghetti case. You don't want to throw it to the wall and see if it sticks. So Judge Sullivan, you kind of, and I think I stole this when I did one of the videos, but it's the three elements. Show me where I'm going. Well, it's your theory. I'll let you do. I don't want to steal all your thunder.
I always say it's real easy. It's almost like writing a research paper, right? Tell me where you're going, right? Your theory of the case. Take me there, right? With the evidence. Closing, tell me where we went, all right? Because you're doing your closing argument. And all three sides. Opening statement, tell me where you're going. Evidence, take me there. Closing argument, tell me where we've been, right? Summarize where we've been on that, lay it out to me. Makes it real easy for the judge, for the jury. Remember, your juries are going to be youth. So you really got to make sure you let them know exactly what your theory is, what the evidence showed, and tell us what the evidence did and why they should agree with you in finding the person guilty, or acquitting the person, find them not guilty, or with your sentence, why they should agree with your sentence, why your sentence is fair and just. So three things. Tell me where you're going, take me there, closing, tell me where we've been. Mike?
Just gonna one more comment, then we can move on to the next section. I see you guys just on a very spirited argument about the case and information. Just remember, this is a mock it is a real case. This is all the information you're going to have. So I see some good ideas about medical examinations and brain damage and talking to nurse and video recordings, and that's all stuff that I'm sure everybody would like to have, that you have all of the evidence you're going to have for that case. So while it's good to think about those things, you also have to remember you're limited to what you've got. And I experienced that in my case. There's a lot of cases I wish I had video evidence. I don't have it. So I have to use what I have to make my theory. And sometimes I have theories that I know are true, but because I don't have evidence to prove it, I have to discard the theory. So I think your guys' conversations and thought process is great, but at some point as attorneys, you have to recall, or you have to realize at some point you have to cut your losses And while you have a great theory, if you don't have any evidence, you have to discard it. So a lot of the things you guys are discussing are things that'd be nice to have, but remember, you have witness statements, and that's it. So, if you guys want to have maybe some conversations about the case on that, talk about the evidence you do have. And additionally, just make sure you're still paying attention to what we're talking about here. And you guys want to continue to have those discussions maybe after class in the Discord and things like that, that'd be great. But just remember, you have all the evidence you're going to have. We don't have any, I'm not going to give you a surprise medical examination report in 2 weeks and it's aha, because we don't have aha. So that's all. And this is actually a real life trial by peers case. Usually this is all you have is a police report and some statements, and that's it. So just keep that in mind as you guys are discussing the case.
Yeah, I remember I saw a lot of things with the medical exam and brain damage. If there was a brain damage, that case wouldn't have come through us. That would have been assault or battery, with substantial harm. We would never get that in trial by peers. That would be too serious of a case for that. So remember what the charge is. The charge is a disturbance, right? So we want to kind of focus on that and get that evidence. So remember to make your evidence to the charge permitted. It's not, assault with substantial bodily harm. This is a disturbance, right? Causing a disturbance and annoying people and that. So remember what the actual charge is. But that's what they're charged with. Due process, you can't add different charges to that trial. So wait a minute. We think it should be more serious. The state gets a chance to charge. That's what the state charged with. So that's kind of what you want your evidence to do. So remember, you're limited to the evidence that you have presented to you and your witnesses. You don't get a discovery, like you do in our trials, and we can have discovery in civil cases 6 months to a year where they're going out there doing subpoenas. We don't do that. We're kind of focused on the evidence submitted and whatever witnesses that were presented in the police report. So you don't have the luxury to really do independent investigation like they would do in criminal cases on that. So good job. Nice job, everybody. We got our theory of the case, right? Prosecutions realized their theory of the case, that Mr. Small started it. He was the bully. He caused that trouble. We got defense saying that it was kind of just defending himself on that he was just there on that. So it's not a disturbance. You talk to your senior attorney. What do you want to do next now? So now you talk to the witnesses. You talk to your senior attorney again or for the first time on that. What do you do now as to your witnesses? What do you think? What's our next step? All right. The next step, we interview witnesses. If you need to get something that you missed, you talk to the attorney. You talked about your theory of the case. You guys have talked about, here's what we're going to do, and we're ready. Here's our theory on that. Have we proven everything that we want in our theory? Oh, nope, I need to go back and talk to this witness, ask some further questions about this. I need to re-interview this witness to fill up some holes we may have. So after that, you've got your theory, you consult with your senior attorney, see if you need to follow up with another witness to re-interview witnesses in case there's some questions you missed or some other questions that you wanted to ask. So make sure you talk with your senior attorney and see if there's any about your theory of the case, if there's anything you missed or anything that we need to re-examine with our witnesses to finalize our case in chief, where we're going to go. And then once you got that and you figured out we're ready to go, right? You know our theory. Your next step is what? What's your next step? We talked about that. We re-interview witnesses if we needed to. What's our next step?
You talk to the opposing side of it and negotiate some terms if you need to.
Absolutely, Marie. Now we should have, right, strong case, or we know a strong understanding of our case. We've interviewed witnesses. We've read the case. We've talked to our senior attorney a couple of times, maybe. We got a good feeling what the case is all about. Now we can contact opposing counsel, say, okay, right, then you negotiate. You start talking about it. What's that? Your strong point. They're going to tell you what their strong point is. Right? Can go back and forth a little bit talking on that. And I think as Michael, Mr. Sullivan, and Ms. Quinlan and Ms. Schumann would tell you, of course, 90 to 95% of cases never go to trial. Criminal cases, our family court cases, 90 to 95% in my child abuse cases are resolved. They are negotiated out. When the attorneys get to handle their case, what their theory is, they talk to the other side, see what they co-counsel, see what they think is fair and just. Right? So, okay, here's what we think. The other attorney's going to put their defense, say, oh, state, you're wrong. You can't prove that, do this. You go back and forth and see if you're able to negotiate what you think would be a fair and just settlement with the negotiation. See if they plead on that. Mike, anything you want to add about the negotiations after they got a good handle on their case?
Sometimes negotiations can tip. Sometimes you can get information from the other side based on your negotiation, how your negotiation goes. If someone is very adamant about not negotiating, that can either usually mean that sometimes it means that you may be missing something in your case. So you want to pay attention to negotiations, even if you don't get anywhere with a negotiation. It may give you an idea of what the other side has, or maybe give you a better idea of what you've got, because if they're adamant they don't want to move, you either have a very stubborn subject matter on the other side, or if you're not willing to budge, maybe you're the one being stubborn. So negotiations are just as much about getting an idea of where everybody's head is at with the case, as it is the other, the actual negotiation result. And remember, you don't want to be too stingy on negotiations. This is usually a way to avoid trial. If you don't think it's necessary on either side, it's a defense. Maybe it's a way to get a lesser sentence. Maybe you're like, oh, I know my client's guilty. I don't really think I can win, but maybe if I negotiate a lesser sentence, the state will give me a lighter sentence for not having to go to trial. And you do that in real life too. Whereas with the prosecution, you want to throw the book at them, 40 hours of community service, 3 jury duties. But you got to remember, if they're coming to you pleading, they're right then and there, they're admitting guilt to a point. And if your whole point is to get them to recognize that they are, they committed a wrongdoing, that will, you want to all right, well, they're at least admitting something's wrong, so we don't need to throw the book at them. And I think in the video this week, we had an example of a bullying case. Now, if it wasn't in this week, it's in one of the other weeks, because I know I use this. But if you've got a kid who started a fight, he punched someone in the face. So let's just say Judge Sullivan and I are in school, and Judge Sullivan, I've been bullying Judge Sullivan all my life, or all his life, and finally Judge Sullivan's sick of it, and he punches me in the face, and he gets charged with a fight. And you come to the negotiation, and it's like, well, he knows he did it wrong. He knows he shouldn't have punched Mike in the face, but Mike's been bullying him for 3 years, and Judge Sullivan finally just got sick of it and stood up for himself. He knows what he did is wrong. He knows he shouldn't be violent, but given the circumstances, he did what he did. So now, is that something you want to throw 40 hours of community service at, or do you want to be like, well, given the circumstances, and he's admitting he knows he did something wrong, and he knows he shouldn't have done that, but we still need some kind of rehabilitation, some kind of community service. You think you're more apt to give him 40 hours, or you think maybe you want to give him like 10 hours? And if somebody wants to unmute their mic, I'll tell you what, if somebody thinks we should give him a harsh sentence, go ahead and open your mic and tell us why. And don't be shy if you feel that way, that's fine. No takers? All right, everyone's a very reasonable prosecutor here.
And you got to remember, if you're talking to co-counsel, if you want to negotiate a matter, you got to give them something. You can't come in and say, okay, you're going to do 40 hours community service, 3 jury duties, the workshop for anger management or whatever, conflict resolution, and a letter of apology. Well, how can they negotiate that with their client, right? You're throwing the max at them. You give them really nothing to negotiate. So you want to give them, they come back and say, well, what if we do, 24 hours of community service? So you got to get a little give and take, because you just want the maximum on everything. There's no way they can resolve that, because what can I go tell my client that they want the maximum? So if we go to trial, what's the worst we're going to get? The maximum. So why not go to trial? Maybe something happened, we get a jury. You never know what a jury's going to do. You might as well roll the dice, because the state hasn't given us anything. So you have to be reasonable and talk about it. As Mr. Sullivan says, you've got to justify anything, your recommendation. And in those cases, you got a bully in, you got that. We still can't say, Sullivan, it's okay to punch somebody in the face. You're a bully, it's okay to punch in the face. No, that's not self-defense. It's retaliation because Michael's been bullying me. Well, they still got to be held accountable for punching somebody in the face. It's not how he handles those things with the bullying. So that's why it's still got to be held accountable. But you say, well, maybe do a lesser sentence, because we understand the circumstances. He just had enough. He's been pushed. Finally, there was a straw that broke the camel's back. Wrong way to react, but he shouldn't get the same as if I just walked up and punched Mr. Sullivan in the face just for the heck of it. And if you see Mr. Saloon, you can tell I punched him, and he's been punched in the face many, many times, as you can tell. So he's no, I'm just teasing Mike. He's
No, it's I got hit in the face with pucks from playing hockey.
Fire
Not
hard,
getting
there
punched.
you go. All right, so remember, you negotiate, you gotta give the defense something, otherwise there's no way they can negotiate if you just want the max. And plus, remember, it's about rehabilitation, it's about justice and fairness. So you want the subject minor going through it to feel that it was fair and just, they got a fair shake, that the state was reasonable to them on that, but they just think they got screwed. You don't get what we really want. We want them to accept accountability. And if it's a fair sentence, they're more likely to accept that, right? Which is what we're all about, is the rehabilitation, to accept it, said, you know, you're right, instead of saying, now, some can never get that. Some, no matter what they do, they're never gonna admit they were wrong. But the majority of people can take that back and say, okay, I screwed up, and while I may disagree, I understand why they did it, and I accept responsibility. That's what we want, accountability, so that they will rehabilitate and change their behavior by accepting responsibility and move on and change their behavior in the future. Anything else you want to talk about, Mike, before we get to last week?
I think that's pretty much it. Do you guys have any questions at all about the 1 week before? Or second, sorry, 2 weeks before? Which week were we? No, we were on 2 weeks before.
Yeah, we're on 2 weeks on that, right? We did week 3, which is the first week of your preparation, 3 weeks for a trial. We just finished up now with week 2, where you re-interview your witnesses, talk to your senior attorney, figure out where you're going to go with that case, contact opposing counsel, see if you're able to maybe work something out through negotiations. Now we're the week before trial. All right, so we're getting ready to go to trial. So what are we gonna do now? We're getting ready to go to trial. We talked to co-counsel. Next, Julian.
I think someone did someone accidentally unmute their mic, and someone have a question?
It was an accident.
Oh, okay.
Okay, Mike.
Oh.
Not a problem. All right, so we're ready now. It's 1 week before trial, right? We have finalized our theory of the case. We said, okay, now we're getting ready to go to trial. Here's our theory of the case. We conferred that with our senior attorney. We've re-interviewed everybody. We're ready to go. Now we gotta get our actual work done. We're now getting ready for trial. So what are you gonna do now? We're actually getting ready to prepare our case before the court. What are we gonna do?
Are you going to make an outline of the case?
There you go. Good. Is that Nikki?
Yeah, sorry.
Absolutely. Got to outline your case, right? Right? What are we gonna do on this? Because you just can't wing it. You're gonna sit and say, okay, now we're getting ready to go to trial, and I'm going to outline my case. And what's that going to include, Nikki, when you outline your case? What are you going to want to talk about?
It's going to include opening statement, your examinations, and your closing argument.
There you go. Exactly, right? You sit there, and again, along with your co-counsel is going to do it, prepare your outlines, address your opening statement. Remember, opening statement, tell the court, the jury, where you're going to go, right? What's your theory of the case and what you're going to prove, right? Then your examination and your cross-examination. Remember, you get direct examination to your witnesses that you're going to call. You get to ask them questions directly. Defense gets to cross-examine them. Defense calls their witnesses. The state gets to cross-examine their witnesses. So figure out what your direct examination and your cross-examination of each witness. What do you want? Why is this witness? Why are you calling this witness to testify? What are they going to bring to help establish your theory of the case? Cross-examination, same thing. When the other side put their witness on, what can you do to undermine their testimony on that to try to establish your theory of the case? Cross-examination is very difficult. It's an art. It takes lawyers many years to become good at it. Some never become good at it, but you want to outline it exactly what the type of questions you want from your witnesses, and what type of questions you think you're going to ask opposing counsel. Hallie, do you have a question, or just turn off your mic by accident?
Looked like it was an
Looks like it's an accident. So good job. Outline your opening, examination, direct and cross, and closing argument. Remember, opening statement, tell the court where you're going. Examination and cross-examination, take us there. And then closing argument, tell me where we've been and why we should rule in favor of the state or rule in favor of defense. Tell us where you're going on that. Mike, anything you want to add as to opening or examining? I know they go in more detail to help you in future ones, but that's just to kind of get you going.
It's pretty much what I just typed. We're going to teach you guys how to question witnesses. We're going to teach you guys how to do cross-examination. So this is all stuff that you're going to learn a little bit later, like week 3 and week 4. So we will absolutely teach you how to handle all that stuff. So that'll be a little bit more interactive today than today, because you guys are actually going to practice your questions with us.
Yeah, and again, today's just kind of an overview and preparation to give you the big picture. We give you kind of the outline of your case preparation strategy. Then future cases, we would give you those skills, what to do, examination, evidence, things like that. And then mock trial, we give you a chance to practice it in more detail on that, put the whole package together. So remember, today's just kind of give you the overview of your case preparation. Then we will take you through each of those elements with evidence, examination, hearsay, things like that. And then with opening and closing, we're kind of help you with the details. And then at the end of our course, you get a chance to put in practice yourself with the mock trial. And then when you get real cases, you'll be ready to implement exactly what you've learned through the summer program and what you practice in your mock trial. Anything else you want to add on that, Mike?
No, I think that's it for now. We're going to go over a lot more of this stuff as we go. You got to remember, you don't need to make a trial more than it is. You have limited information in front of you guys, and you don't have the opportunity to actually talk to the real people that were involved. So just remember, when you get to the trials, some of it you may have to fill in the blanks a little bit on your own, because you guys are going to be your own witnesses at these trials. So you will, and then that means the other side is going to have to be prepared. There may be an answer or two there that they didn't expect. So, but you don't need to turn a direct or a cross-examination from 5 minutes into 20 just to ask more questions. I literally, the last trial I did, I had a cross-examination, was 1 question. That's all I needed. So, because you don't have a lot of information here, we're not expecting you to put on a half an hour trial. It's just, you just don't have the information. They're short on purpose, so you can focus on the important things. And then we have a lot of kids, so we're gonna have to cycle through a lot of these faster, but sometimes this is all you have, and you don't learn much more. So it doesn't need to be very, very long. It's just a matter of practicing. So I saw a question about affidavits and things. You have everything you're gonna get for this trial. You may get a little bit of difference and variance just because you guys will be your own witnesses, and you may answer things in a manner, or you may accidentally or just even on purpose fill some stuff in. And that's fine, because we know you're not working with real people, you're working off statements. So but the big point of that was to say, we're not expecting you to put on an hour-long trial. You may only have 3 or 4 questions, and that's fine.
Yeah, absolutely. Sometimes no questions. If that witness doesn't do anything to hurt your case, they haven't asked right questions on that, you don't want to give them a chance, right, to hurt your case. If that witness didn't say anything that hurt your case, you may not need to cross-examine. As Michael said, sometimes one question, we had a trial going this week on that, and there was an eyewitness kind of thing, and the defense attorney just asked him one question. You wear glasses? Oh, yeah. Did you have the glasses on at that time? No. How far away were you? I was across the street. No further questions. Right? Didn't get any more details just to show that eyewitness for the state wears glasses, didn't have the glasses on, and was 100 yards away. Right? So they know in closing argument they're going to say their eyewitness didn't have their eyes on. So, right, short and sweet on that. So again, just figure out what you want to get through from that witness when you ask your direct examination, cross-examination, anything that you think that you want to bring out on that helps your case or does not undermine your case. So again, you're focusing on your trial. We're getting ready. Make sure you coordinate with your co-counsel, right? So you both are on the same page and that you shared your outlines, because again, you got to be prepared to do the whole case in case something happens to your co-counsel. We've had it, emergencies, co-counsel gets sick, co-counsel driving over to court, got in an accident, right? And now we're there. You can ask for continuance, but we don't like to continue these, especially we got witnesses, because we may have the school police testifying in a real case. You may have the school dean testifying and say, oh, I'm sorry, come back another day. The judge may not allow that. So you really want to be ready to go and say, counsel, you're here. I guess you got to take the whole thing. So make sure with co-counsel, you guys are both prepared to handle the whole case by yourself if it happens. Now, hopefully it won't, because you want to equally divide it. One do opening, one do closing, one examine one witness, one examine the other to equally divide because you're both equally responsible. But just make sure that you're prepared to do the whole trial in case an emergency happens, because it has happened in the past, and nothing aggravates a judge more than attorneys coming in on a day of trial and saying, "Nope, judge, we want to continue it." If it's real emergency, sometimes we do, but most times go to say, "It's not emergency counsel. Weren't you co-counsel?" Well, you should be able to handle it. Anything with that, Mike, as far as?
That's why it's important to have outlines. I do outlines for my cases. In fact, if you guys want one day, I can show you the outlines I do for mine, because that way, if I can't make it to work that day or something happens, I not even a co-counsel. I have, sometimes I've had people just, can't make it. Here's my outline for this case. Can you do it? And that way it's detailed. My outlines have all the points I want to hit and all the evidence that I have, page numbers, and what report I'm looking at, what page number it's on, so they can go to that instantly to find it. So it's very, very important for you guys to make outlines for now. And in fact, I would recommend you always do one, but that way, if you can't make it, like Judge Sullivan said, you can hand your outline to your co-counsel. They can do the whole trial based on your stuff. You've still done the prep work. They're familiar enough with the cases that they can, they'll be able to use your outline to do it. And like I said, someone remind me at the end of the trial. I'll tell you guys, everyone, an amusing story about my one question, because I think, I don't even think you know this. You'll get a kick out of it. So.
Good. All right, so make sure that week of trial, you're ready to go. All right. And again, contact your senior attorney if you got any last minute questions or anything, saying, hey, make sure, I think it was brought up early, make sure your witnesses are available on that date. Follow up with them that week before trial. Hey, we got trial on Thursday, right? Remind them, let them know. So you want to contact the witness, make sure they're going to be there, remind them to be there. If you don't show up, again, you can ask for a continuance if the court find there is excusable neglect on that you've done everything. They ignored the subpoena. There's some defense on that, but the fact is you want to make sure your clients are going to be there, or your witnesses, I'm sorry, are going to be there. And I think Mike will talk about subpoenas. We're not get there yet.
We haven't really gotten there yet. I will say, in addition to talking to your co-counsel, if anything like that happens, if a witness isn't going to be available, if you can't be available, or if something catastrophic goes, with the trial, you want to reach out to Katya and Patrick and let them know, because they get in contact with the court, they get in contact with those witnesses, they can get in contact with the judge. So we're made aware of what's going on. So just be advised, if anything like that happens at all, let Katya or Patrick know. It's very important that you do.
All right, and we can help you with that too, to make sure that we know. I just don't want to wait the last second if you know it's coming in advance and bring it up in court, because it causes a lot of inconvenience for people, the witnesses that were there. So the court hates it when it happens at that last second, because a lot of people have put a lot of work in. They're here. You might have to take off time to be there. And sometimes the school police testify. It's their off time, and they're coming down to testify, and you have to come back again. So the court really does not like to continue that unless it's absolute emergency. So let Patrick know or Katya know as soon if there is a problem on that, because they might be able to resolve the problem for you anyway. So just make sure you let us know. Just don't wait the last second. And that comes right back to where we started, preparation, right? Being prepared, not waiting till the last minute. Uh-oh, I got a problem here. Again, the preparation is throughout, from 3 weeks before, right up to the week of trial, right up to the night of trial, right? You may be communicating right before we go into court. The negotiations come out, and it might be something, okay, now they want to talk about it. Because sometimes the kids may start at the last second, because defense or subject minors see witnesses showed up and they say, uh-oh, right? Sometimes people want to go to trial, and then they see the witnesses showing up and they say, well, maybe we could settle this case now. And of course, fine with that, because again, we'd rather have a case negotiated if it's fair, and then go to trial unnecessarily on this. So sometimes they'll settle at the courthouse door, so to speak, on that. So always be open and ready to address that. And again, be prepared. If you're prepared, nothing will be a surprise. There's nothing we can throw at you that you can't handle. Michael?
Someone has said they had a question. Zahira, do you have a question? You want to unmute yourself and ask real quick?
Yeah, I had a question. I'm sorry, but I wanted to ask you could repeat what you said about the 3 statement things.
Oh, about the opening, about tell us where you're going. Opening statement should tell the court, tell the jury where you're going, right? What is your theory of the case? what you're gonna prove. We're gonna have Mike Sloan's gonna testify that, that Ronald Smalls have punched so-and-so in the face or whatever, right? So you tell us where you're gonna go, what's your theory of the cases, and who's gonna testify and tell you about that case. Then during trial, you take us there, you take the court there, right? You take your witnesses, your evidence, you take us to where you said you were gonna take us. I'm gonna prove this to you, they're gonna tell this, right? Then take us there with your evidence and your witnesses. Then in closing, tell the court and the jury where you went. I told you, here's what my theory was, here's the witnesses you heard, and here's exactly what we showed you, judge or jury, here's what we proved during trial, take us there. So that's kind of your thing. Opening, tell us where you're going. Trial, take us there. Closing, tell us where we've been, what you were able to prove, and then the jury will then render a verdict or the judge guilty or not guilty. But that was kind of the three overview on that. Tell us where you're going, take us there, tell us where we've been. All right, so again, we're right up there. Remember, you should be starting to prepare 3 weeks before trial. All right, so a quick review, and then we're going to talk into some plea bargaining or sentencing and let you guys get out of here. Week 1, which is 3 weeks before trial, read your material. Familiarize with the facts, witnesses, the charge, exactly what is the charge? What is the client being charged with? Or what's the state charging on that? And what you need to establish for that charge? Contact your senior attorney at that time if you want before you interview witnesses. Depending on what you want to do, ask any questions to your senior attorney if you need to do that. Then interview your witnesses. And again, you can do that after you talk to your senior attorney. You may want to do that before you talk to the senior attorney so they can help direct you what type of questions you have. Then 2 weeks before trial, make sure you have met with your senior attorney, talk about your case, your witnesses, what they need to do, and what your theory of the case is with your senior attorney so they can help you prepare. Go back and re-interview witnesses if you need to. And then basically getting ready for trial on week 3, 1 week before trial. Finalize your theory, talk to any of the witnesses. If you need to go back again, consult with your co-counsel and your senior attorney. What we're going to do at trial, outline your opening, direct examination, cross-examination questions, closing arguments on them. Be prepared to go to trial. And throughout, always remember you can negotiate at any time on that, even the night of trial, if it's fair. And the bottom line is preparation, 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 right? Prior preparation prevents poor performance. Remember your 5 Ps in anything you do, whether it's a job, or preparing for a case. If you are prepared, you'll be successful in whatever you pursue. That's the key. You don't have to be real bright. You just have to be prepared. And it becomes obvious to the court, in my court, which attorneys are prepared, which ones are not prepared, and the ones that are not prepared do a disservice to their client. And it's unethical to not be prepared to represent your client. Mike, anything you want to do? Mike, maybe you want to take over plea bargains or anything you want to highlight? I kind of did a quick summary of the 3 weeks of preparation.
Yeah, I'll just add one quick thing on what Judge Sullivan was talking about preparation. And I know it's in bold in your the case prep strategy sheet we gave you. If you get a case and you realize that your next 3 weeks are busy, you've got exams, you've got a paper, and even if it's stuff in your personal life, if you can't dedicate those 3 weeks to your case, let Katya or Patrick know immediately, because it's not, like Judge Sullivan said, it's not fair to the clients involved, it's not fair to the program, it's not fair to you, because you don't want to take a case thinking, well, I know I can get this done, and then you don't, and you don't want that to, you don't want to feel bad yourself. You don't want it to look bad on you. So this stuff's about time management. If you don't have the capability and time to dedicate to that case, there's absolutely no problem with saying, hey, I'm sorry, I just don't have the time right now. We know you're students. This isn't your job. This is extracurricular stuff you're doing. So if you don't have time to it, it's more than fine to tell Katya and Patrick, you just don't have the capability of doing a case right now. As far as the outline's got some stuff about plea bargaining, and I'll just touch on it briefly. We don't need to rehash everything. The most important parts are this: you can bargain at absolutely any aspect of the case. Like Judge Sullivan said, sometimes that stuff happens right as you're walking in for trial. That happens in real life too. So, if you think you can negotiate something and you feel like you've got the ability to do that, talk to opposing counsel, talk to your co-counsel, talk to your senior attorneys. In fact, if you think there's something they should negotiate out, I definitely talk to your senior attorneys, because maybe the two senior attorneys can get together. We're here to teach you guys as well as help you. And maybe it's something that really should be negotiated. And you've got the other side just being a little, they want to go to trial and win. That's not what our program's about. So, that's always something you can do, is negotiate. All phases of the case can be negotiated. The guilty or not guilty plea, the sentencing, anything that you can negotiate can be negotiated. So don't think that just because you're going to trial, that's it. If you go to trial and however that ends up, you can still negotiate the sentence if you want to, or the other way around. You negotiate out of the trial, but then you argue just sentencing. And that sometimes you can offer. It's like, hey, if you want to go to trial, maybe we'll not discuss this or discuss this, but in exchange for that, you're going to agree to this sentence. It's basically almost as much as you can negotiate. The only rule is anything you negotiate and plead out to, both the prosecution and the defense senior attorneys must sign off on that. So if you think you have a good deal between the peer counselors, reach out to your senior attorney and talk to them. They'll contact the other senior attorney. If they approve it, then it can go in front of the judge, and then the judge gets the final say.
I have another question.
Sure.
Can you repeat the 5 P's that you said?
Oh, that's you.
Okay, that's prior preparation. So prior preparation prevents poor performance. And again, remember 5 P's in everything you do in life. If you do that, you'll be fine from your work, from your career, whatever you do. Prior preparation prevents poor performance. That means you're prepared, you'll do fine. May not win every case, but you'll do fine because you've done your preparation.
Okay, thank you.
You're welcome.
Yeah, and listen, as far as Judge Sullivan has brought something about you may not win a case. There's nothing wrong with losing a case. Sometimes you just have a case that your client wants to go and you know all the evidence against them. Sometimes you just don't have a case, but you're the state and you have to. So as long as, and this is what I believe I've been taught, as long as you put on all of your evidence and you do as much work as that case requires, you'll never feel bad about a case. I just hit my 2-year mark at the district attorney's office 2 days ago. And I almost went 2 full years without losing a trial. I finally lost one a month ago because my client insisted that we go. And I was like, we don't have the evidence, we're gonna lose. No, we think we're gonna win. And I went and I put on my evidence as best I could. I asked the right questions, everything I could, and I lost. And that's fine. So that's just how the law works. Sometimes you get a case and you can't win, but you have to go do your absolute best. That's the most important thing to take out of this, in addition to helping the subject matter, is you do your best and let the chips fall where they may. Sometimes you get a judge who doesn't know what they're talking about. You didn't see that, did you?
Nobody that I know.
Yeah. Sometimes you get a judge and they just don't understand where you're going, and that's fine. That's just how it works. So just be prepared, as prepared as possible, and know you've put in the work, and that's the most important thing. I see a few questions here. Do you want to talk about the judges that participated? Would you like me to?
Okay, I'll leave it to Mike.
Judge Sullivan's basically at all of them. We have people that appear as judges that are actually attorneys, like one of the instructors, Felicia, that's going to be teaching next week. She usually appears as a judge. I have done judging as well as senior attorney. I think one more judge is definitely going to come. The judge I appear in front of, his name's Judge Gibson, so he was interested in the program. So I think he's going to help us during mock trial week, and he may jump in on one of these Saturdays, so he can pay attention to the program. So it's not just actual judges, but we do have a few actual judges in the program. Do you know any other judges that I'm not thinking of?
We've had in the past, we had Judge Giuliani do a couple on that. What happens is many times it was after hours. Many times we have judges that come in, they do a case or two, and then we kind of lose them. But we've had Judge Giuliani, we had Judge Assad from downtown. I think Judge Bell might have done a couple. So from time to time, we get other judges that volunteer. We're trying to get more long-term than just me on that. So we're trying to get some other judges, but many times that come do a couple trials and kind of disappear on us because of family reasons or business reasons they have. But right now, I've been the oversight Judge Elf. We got Judge Elf 2 cases. So they come and go on that as available, depending on how many cases we get. And if we're able to do them back live on that, we'll again see about judges again that want to participate. And I'm actively recruiting Judge Gibson. And I'll go back to Judge Giuliani, see if she's able to get back in on that. But it kind of ebbs and flows. We get some judges involved in it. They do a couple as they can. But long-term has pretty much been me for the long term. It's as good as it gets, I guess.
It's
As good as it gets. Any part in the store, baby.
when you've got steak, why do you want hamburgers, right?
There you go.
Don't compliment him. He'll never forget it. So I know we're getting near the end of our time, so I'm going to just skim a little bit of the rest of the plea bargains. The final thing I'll add to that is, remember, no matter what you plea or negotiate, the judge has the final say. So if you think you want to reduce someone's sentence or something like that, and the judge disagrees with you, in fact, there was one case that we had, one of the last cases that we had before COVID, where the client had pled guilty. The client and the prosecution, the defense had argued a lesser sentence, but the subject minor's mother was there. And the subject minor's mother asked to approach the judge. I think you remember which one I'm talking about, and basically said, my son has an issue with substance abuse already, and I need him to learn. So Judge Sullivan thought it was in the best interest of the child to have the maximum sentence to teach him a lesson. And that's what it wasn't to punish him, but it was, you need to learn the repercussions of your actions and what this could do to you long term. So the point I'm trying to make is, if you negotiate something and you bring it in front of the judge and the judge changes their mind, there may be other reasons that you're not aware of, because the attorneys didn't know about the mom approaching the bench to talk to him. Something happened off the record. So just remember, and also that works out in your negotiating. You don't want to negotiate something too high or too low, because the judge gets the final say, and he's like, well, I don't really agree with that. We'll plead out, but this is what we're assigning, and that the judge gets the final say. So just remember that as you're negotiating, the judge may override you, but that's fine. There's usually a reason for it.
Excuse me.
Sure.
If the judge didn't agree with the sentencing negotiation, would they change it right there? Would you guys have to find a new negotiation to do?
It depends. If it's me and we have time, I can send you guys in the back to further negotiate, because I want you guys to kind of do it. If we don't have the time, then I may do the sentence directly, since the fact that, it's my time. But if we have time, I would ask you guys to go in the back of my courtroom, see if you guys give you 5 or 10 minutes to try to figure it out, because that's important. The process is important. So I like to have you guys figure it out with process, but it depends on the time factor. If we're running late that day on that, I don't want to tie people up too long on that. I would sit there and say, then the court will enter the sentence. So it can be both. Most of the time, the court enters the sentence directly then. But in my court, if we got time, I would send the people in the back, say, see if you guys can come up with something else. So it depends on that. But most of the time, in most cases, the judge then would say, I disagree with that sentence. I'm going to impose a sentence directly myself.
Thank you.
Good question.
One last thing on pleas. Specifically the sentencing. So there's the 4 elements: community service, jury duties, classes, and letter of apology. Each one of those elements can also be negotiated. Let's just say you agree that someone needs substance abuse classes, and you agree that they should sit on 2 jury duties. But some of you guys, so the prosecution may think you need higher community service hours and the other thing's lower. So you can negotiate the other elements and then just argue on community service. So don't think that it's all or nothing on the sentencing. So that's basically, do you have anything else you want to add on, please?
Now, just with the sentencing, just remember that you have to have community service. You have to have jury duties, you have to have a workshop, and you have to have apology. The number of those hours and things like that are jury duties is negotiable, but those 4 elements must be in every sentence. And if there's more than one charge that they're pleading out to or found guilty of, it must be for each charge. Each offense they were found guilty of or what they admitted to, it must be community service, jury duties, workshop, and apology for every count. And again, within that, you can negotiate what how many hours should be for community service, how many jury duties, things like that are all negotiable. What workshop would be better for conflict resolution, or maybe a drug workshop if it's really was referred to substance abuse. Those are negotiable on that, but all 4 of those must be in every sentence that you recommended. And again, you must justify that or argue that to the court or to the jury why that is a first sentence that you are recommending, even if it comes out with the negotiation. Sometimes if it's negotiated, you guys have agreed everything in the sentence, I may still have you explain why I should accept that sentence, just to give you guys some more practice. I'll ask the state, explain why you agreed to that sentence, why you think it's fair. Then I'll ask the defense the same thing. Tell me why you think that's a fair sentence, why I should accept it. And again, because I want to give you guys that chance to practice on that, to say, okay, judge, here's why we think it's a good sentence, even though both sides agreed on it. And remember, the bottom line on that thing is the subject minor, right? The youth going through that, facing the charges, they have the final say if they're going to accept that or not, right? It's their life. They have the final say if they're going to agree to that or not. You can counsel them. Of course, you definitely want to counsel them why you think it's good for them. But again, they are the final one. It's their life. They have the final say. If they will agree to it, then of course the judge has to approve it. Michael?
Judge Sullivan already kind of touched on the biggest thing I wanted to discuss in the sentencing section. It is very important to discuss, to argue those. And I won't beat a dead horse, but that's definitely something you definitely want to do. Make sure you're justifying everything. With regard to sentencing arguments, you'll get a rebuttal, and you want to make sure rebuttals are very tricky. So you get, the prosecution will get to go, the defense gets to go, and then the prosecution gets to go one last time in a rebuttal. Now, you don't want to just rehash everything you said. The key thing in rebuttals is attack what the other side said. So if the defense brings up a bunch of arguments, you don't, if they bring up A, B, and C, and the prosecution gets the rebuttal argument, you don't want to talk about D. Attack A, attack B, attack C. A lot of the times in real court, we have rebuttals that they don't ever touch on what the other side argued. So you want to make sure you're doing that. That's the most important part of really what a prosecution does in the closing, is attack the rebuttal. The defense, they have their usually prepared closing, but if they can attack some of the things that the prosecution said in their closing, they definitely can as well. But it's very key for the prosecution not to just rehash their argument. You want to make sure you're attacking the defense's argument on the rebuttal. And then the last thing is, we've already went over our mandatory stuff, which is the community service hours, the jury duties, the workshops, and then the apology. And you can be creative. That's not the only thing you can do. If you think there's something else that the student can do to help them, or the subject minor, bring it up. That might be something you can negotiate. That might be something you actually even ask the court. If you think this is a good option, it might be better for something to, sorry guys, I'm getting weird messages on Discord, so I'm gonna shut it off for a minute. If there's something you think it'll be beneficial for the student, bring it up. So it's not just limited to those things. That's just the minimum. So, but definitely if you have some kind of outside suggestion for a sentencing, bring that up to your senior attorney first. Crystal, objections don't really come in until later. That we'll go over that in detail. It's almost its own class. So, but you can definitely object to things in arguments, but there's specific ways to do that. So, do you have anything else you want to add to the sentencing, Judge Sullivan?
No, I think just remember that, and remember the bottom line. We're here for restorative justice. We want to do fairness and justice and rehabilitate. To keep that focus in mind, everything will be well. From today, we just want you to remember preparedness, right? Be prepared. We kind of showed an outline of how to be prepared. That's the key. If you're prepared, everything else will be fine. And just remember, the ultimate goal of the system is fairness and justice. That's what we're all about. So try to be fair and just in your situations. And not win or lose, because sometimes attorneys get caught up in winning or losing and they miss the big picture, which is all about justice and doing the right thing. As a judge, there's cases I have, as a judge, throughout cases when I knew the person did it. But I thought the state did a wrongful search and seizure. So the Constitution, I thought that was illegal search and seizure. I threw a case out. I knew this person was bad news. I knew this person was selling drugs. I knew this person had illegal guns. But I threw the case out because I had to do was fair and just. And state had violated this person's constitutional rights, in my opinion. So that's what it's all about. So even if the judges, we try to do what's fair and just. Remember, that's what we're trying to do. Not win or lose, but do what's fair and just. About this, as a judge, do I enjoy? No. I saw the last one as a judge. Do you enjoy watching movies about the law? No, because they're all BS, and I start analyzing. So that's not the law. That's not what a judge would do. So I never watch them because I get stupid. Go on, Mike.
I'll tell you, there's a couple movies that are legit. But I'll get into that in a second because we're running out of time here. I didn't, when I saw Crystal talk about objections, I didn't see that Philippe asked a question, which is if counsel goes outside a topic on the rebuttal, can you object to it? Argument, not, it really depends. What you can do is if they bring up facts that are wrong or that weren't brought up in the case, you can make the objection as an outside or make it basically, what is it? Not the evidence presented. Yeah. So you're basically bringing up evidence that wasn't presented. If you're just making an argument, you really can't object to it unless that person's going way overboard. But on cross-examination, it's beyond the scope. So if I ask questions about X, Y, Z, and then on cross-examine, they want to bring up A, it's like objection that's outside the scope of direct, that they cannot do. So you have to be careful if you prepare a set of cross-examination questions and they don't bring it up on direct, you can't ask it on cross. I mean, I guess you could try and see if you can get away with it, but if you want to be ethical, you probably shouldn't. So I don't know how you feel about that as a judge or.
Yeah, no, what happens as a judge, I don't like people objecting to argument because it's argument, right? So it's not thing, it's just argument unless they go way out of line. If they go on there, they try to argue evidence that was not submitted, I'm gonna stop that right away. It's not fair. If you go beyond and rebuttal goes a little bit farther, I give you that feedback. What I do when we do live trials, and while we're waiting for the jury, right? The jury go in the back to decide. We give our senior attorneys and our peer counselors in the back room, we give them feedback, always constructive feedback. Here's what was good. Here's what I think you can improve in. So we would give you that. I would not stop you in the middle of your argument, say, counselor, your rebuttal is off base. I would never do that to you. We just call you in the back and give you guys feedback. It's always constructive feedback. Here's what you did good. Here's what you could maybe improve a little bit on there, but we would never embarrass you or cut you off. It's a learning process, and you learn and you'll get better and better. As the more trials you do, the more cases you get better and better with it. So we'll give you some constructive feedback, but that'll be in private, not in front of everybody, just in front of all the peer counselors and the attorneys in the back room, so you guys can get good constructive feedback.
Okay, well, we got about 3 more minutes before Zoom may cut us off. So does anyone have any questions about the material? We've pretty much reached the end of the material today. Does anyone have any questions about that?
Just one.
Go ahead, Nikki.
So basically what we want to do is make sure they get the best possible help, like a subject minor. And so when we're contacting opposing counsel, that should be our number one goal in mind, just trying to get a good sentencing agreement for our subject minor.
That's correct. The trial by peers is in a unique position that you're not necessarily trying to win at all costs. So you want to sit down and you guys are going to know. You're going to see these cases. You could probably sit down and talk about this case right here and say, I won't get into the details, but yeah, you'll know. So you'll get down and sit down and say, we think this, we think that. So it's a little more collaborative in trial by peers in real court because you're not trying to just win. You're trying to get the best outcome for that subject matter. So yeah, that's definitely the primary concern on everything you do. And sometimes you can work that out, and sometimes the subject matter is adamant they want to go to trial, and they go to trial. So that's kind of how that works. But yeah, there's an added layer on how trial by peers operates with regard to the best interest of the subject matter. And I see Katya's got her hand raised, but if you want to go ahead and say something.
I think the last thing is, remember, this is a diversionary program. We mean the youth that are found guilty or admit to guilt. If they complete the sentence, they have no juvenile record. So we throw out that juvenile record. There's nothing in their juvenile record from the offense other than it was referred to diversion. So that's the buy-in with the client on that, the fact is that's the buy-in that we do that, they complete that. There is no juvenile record for them. So that's the benefit of it. They have no juvenile record. So if they get in more trouble, they'll be handled as a new case. They won't have this case as a juvenile record. Katya, is there something you need to throw in there, Katya?
Hi, yes. So a few notes just before everyone heads out. The emails that you send out to me, make sure you send me emails about the program. If you have questions about the homework, put it on Discord. Every email you send me must have an email signature. You can also set it up so that whenever you send an email to me, it includes an email signature, so you don't have to type it manually every time. And lastly, this is super important, and I do want, hopefully, maybe Judge say a few words on it, or Mike. Your parents are not the ones in the program, you are. So I need your parents to stop emailing me if you have questions. You need to email me when you have questions. That's it. I think that's all 3 things I needed to mention. And also, if you haven't already put on your chat your name for attendance, email me saying, hi Katya, I did attend today's meeting, just wanted to let you know. Something along the lines of that.
To follow up what Katya said about the parents, we are teaching you a process here. We're teaching you to advocate, right? For another client, speak up for yourself. So we want you, if you got questions, you should be contacting Katya. If your parents have a question, they should ask you, and you should follow up with Katya, because again, we want you guys to take the responsibility, to take the accountability for the process and handling the cases, not the parents. So if you got questions on that, or your parents got questions, they ask you, if you can't answer it, then you should send it to Katya and say, hey, what's going on this, or whatever you need to do. So we really want you guys to take that responsibility for communication and accountability on that. This is your program, not our program. So we really want you to do it. And that's why we don't want the parents sending stuff on that. We appreciate all the parent support. We appreciate when we're live that they drive you there or hang around. They're always welcome to participate. When we're live, they're more than welcome to come sit in court to watch, things like that. So we do encourage them participation, but really any emails should come from you guys to Katya. And if the parents have a question, they should ask you. And if you can't answer it, then you guys should ask Katya directly. Mike, anything?
I think Judge Sullivan, looks like they're not going to kick us out right at 1. So yeah, Judge Sullivan hit the nail on the head. This is programs for you guys. Take the bull by the horns and do it. And there's nothing wrong with that. You're not going to get told you're wrong. This isn't about being right or wrong. I mentioned that to a couple of people in the Discord already. It's not about being right or wrong. It's about learning. Now's the time to learn that stuff. Now's the time to, I know this isn't law school, but one of my law school professors said, now's the time to screw up when you don't have a client in front of you, because that's when it's real. So if you get we're not grading the homework with regard to a letter grade or anything like that. We'll tell you if you got it right or wrong just for your own knowledge, but don't worry about that stuff. This is all about practice. The law, being a lawyer is about the practice of law. You're never perfect. I'm never perfect, despite what some people may tell you. The judges are never perfect. It's always about learning. It's always about, expanding your horizons. Felicia, you'll meet her next week, in a little bit more in detail. She's one of my mentors in the DA's office. She came to me and asked me a question, and I've only been a DA for just over 2 years. So it's always about learning and bettering yourself. So don't worry about getting something wrong. If you screw it up, that's good, because that means you'll learn it. And I guarantee if you screw something up, you'll never forget it, and it will be ingrained in your head. So don't be shy. Don't worry about getting a wrong answer. That's not what this course is about. This course is about learning how to be better at this, both legally and personally.
And I think, as Michael said, no one's perfect. You never achieve perfection, but my saying is always pursue perfection. While you will never achieve perfection, if you pursue perfection, you'll achieve excellence. And that's what I always tell my students on it. Pursue perfection, you never get there, but if you pursue perfection, you will achieve excellence in what you do. And I want to thank everybody for giving up your time today. You can stay in the program up to 8:17. I think someone said it. That's how long you can. Our program is from 12 to 17 years of age. We'll give you more information about case assignments. I said we're a little flux and trying to figure out what's going on with the new juvenile justice program at the harbor. So I'll be meeting with them to work out there and give you information on that. But I appreciate all your time, your commitment, and again, enjoy it. Have fun. We don't want you to be stressed out. We want this to be fun and a learning experience for you. And we'll teach you everything you need to know, and you get better over time. Practice makes perfect. So don't worry about screwing up or don't worry about that. Enjoy it. We don't want you to be stressed out.
Katya's got her hand up again. I'm gonna let her go. I'm gonna bring up one more point, and then if you guys want to chill and ask us questions, we'll stay for a bit. Otherwise, we'll let you go.
I don't know how to turn it off. I don't have any more statements.
Oh, okay.
Help, my phone and I can't get up.
How do I turn it off?
All right, bye. Thank you, class.
No problem. I said this at the orientation. You have
Okay, got it.
a distinct advantage that you've got a judge, and you got a bunch of attorneys at your disposal. Reach out to us, even if it's not about the mock trial, it's not about trial by peers. If you just want to know something, most of us were in this program to help teach you guys stuff, and that isn't limited to whatever. We have an Ask a Lawyer section in the general chat or the Discord. Even if you want to talk like, hey, Mike, I have a question and it's too long. Can you talk? If I've got time, I'll get in the voice chat and talk to you guys. We actually last year for a fundraiser, I did a 24-hour Twitch stream. I don't know how I survived. And one of the students was up to like 2 or 3 in the morning with me. We were talking about barbecue because one of the things we did was I like to smoke meat. So one of the things was I fired up my smoker and we did pulled pork. And I was talking about old Nintendo games that we used to play and how to barbecue. So like reach out to us. We don't care. We're people too. I'm a big nerd. If you guys, if I twisted my camera to the right, it's just a bunch of Star Wars stuff. I've got a replica lightsaber sitting up here. We're all just normal people. So reach out and ask. He's laughing because he knows I'm a nerd. Sullivan's into sports. I'm into sports. We're both big hockey fans. So reach out. We're regular people. You want to talk to us? Just ask us questions about what it's like to be a lawyer, what it's like to be a judge, all that stuff. We're here to help. We're here to ask questions. We're here to let you guys know we're people too. So have as much fun as you can with it because that's what we're here for. So you got any other closing remarks or?
No, I think we did great. That went well on that. I agree. I think the next one Mike does should be a 48-hour stream. I agree.
No.
I agree.
No, I can't play Final Fantasy for that long.
You can't play Final Fantasy at all anyway.
even know
So
what
it
I'm
doesn't
talking
matter. I know, but I know you will.
All right. Well,
Any last minute question for anybody?
Yeah, you want anything? Speak up.
I have a question.
Sure.
So
Oh, you want one question?
from my understanding, the way to turn in the homework that you give us is to send it to the lady. I think her name is Katya.
Katya. Yeah, Katya.
Would it be by email or like do I send it?
Email. Yeah, email's the best, I believe, for Katya because I don't know if she wants it.
Yeah, email. She wants it in email.
Okay, thank you.
No problem. Someone asked me about my funny story. So Tiani's asking me a question. I'll just answer her verbally. It will absolutely help you. We had one kid in the program who had a almost petrifying fear of speaking in front of people. And by the end of the program, he basically gave one of the closing remarks to show how much he had improved and how much, and it wasn't just like I'm nervous. It was like a clinical diagnosis, right? So he had a speech impediment. That's right, I forgot about that. And he got up and talked and for totally confident, more confident than some of the actual attorneys I've seen in real life. So this program will absolutely help you out, even if you don't want to be a lawyer. But if you want to be a lawyer, this is going to give you a big heads up or a big advantage because you're going to know a lot more about being a lawyer than you ever thought you know. We are training you to actually be attorneys. So you're going to know a bunch of stuff that you're going to drive your friends crazy, especially when we teach you how to cross-examine. They'll never ask you questions again because you'll drive them insane. And that's in a good way because like my brain got rewired in law school and I wanted to bring a little bit of that to you guys because it's fun. Like it's scary, but it's fun. And you're going to get out of here in 5 weeks. You're going to be like, my God, I think differently now. I mean, my parents hate talking to me sometimes now because they're like, you're too analytical. We can't say anything around you. So you're gonna learn what it's like to think like a lawyer. It's gonna be fun. So, and Tiani, if you're scared, and this goes for anyone, if you feel more comfortable talking in the chat, talk in the chat. That's why I'm off to the side here typing to you guys. So everyone's accessible.
And what we do in your trials on that, when you get real signed cases, If you're nervous, we work with you. The story Mike was telling you about with the person with the speech impediment, we just let him get up at the beginning, just state his name for the record, nothing else. So you don't have to do anything else. Then all of a sudden he got up and said, can I do opening statement only? We said, great, just opening statement, whatever you're comfortable with. So we let him develop till we got very comfortable. And then by the end, we couldn't shut him up. I mean, so the issue is we go by your own thing. We just have to know if you're nervous and say, I don't really like asking questions right now. That's okay. Maybe just do opening statement.